in my mind, to what happened with the trust code. And that's the trustee duty to inform an account. How many people, I asked before how many people are trustees, how many people are trustees of insurance trusts that all they own is life insurance? A couple of people in here. You have the same duty to account as if there were marketable securities with $20 million in there. And it's really eye-opening. You have to serve notice on every qualified beneficiary. And this is another expansion of what your duties were before. A qualified beneficiary is anyone who has a present interest in the trust and anyone who has an interest in the trust after the present beneficiary dies. So mom sets up a trust for children, and then upon the death of children, it goes to the grandchildren. The trustee now has to account to all the children and all the grandchildren. Okay? That's much broader than what we had to do in the past. Now, within 60 days of accepting your position of the trustee, you have to send them a letter telling them who you are, where you can be found, and the full name of the trust and what their interest is in the trust. Okay? And who established the trust. Also, you have to give the identity of give them the right to ask for a complete copy of the trust and let them know that they have a right to request an accounting. And they don't even have to request the accounting. They're going to be served with an accounting. So trust is established, irrevocable trust, owns only life insurance. Everybody always thought the only obligation you had, the client gave you the money and you wired it out to the life insurance company, and you sent crummy letters, the letters that with the right to withdraw on each one. Nobody ever wrote a letter to each of the beneficiaries saying, I'm the trustee, here's where to find me, and I'm going to start sending you accountings every year. Okay? And imagine with that black sheep grandchild that, if given an opportunity to spend the money, would take it in a second. They're entitled to the same accountings and everything else that all of the good beneficiaries are. All right.
So
yes, Mike?
If it is just an insurance trust,
Mm-hmm.
and it holds the policy, and other than funding that irrevocable trust account with premium and then immediately paying the premium out,
Mm-hmm.
other than the cash flow in and the cash flow out, what else do you have to provide them? Do you have to show them cash value in the policy? Do you have to show them an in-force illustration, or is just the bank account or brokerage account statement showing the payment of the premiums?
No, you have to give them more information about the policy. If I'm the trustee, I order an in-force ledger every year, and I show them the in-force ledger every year. Actually, I'm going to even tell you that what we've started to do is we want to meet with the agent every year for them to tell us that the policy is still the right policy that we should have, and we shouldn't have to go out and buy a different policy because it's not performing as well.
Stu?
Michael?
Hasn't there been successful litigation on the beneficiaries of mom had an insurance contract in here, we've looked around, mom had $10 million, but with the cash that was in there, we could have bought $15 million. We're suing you for the additional $5 million. Absolutely.
There has been tons of litigation out there where mom set up the policy, the trustee owned the policy, they paid the premiums right on time. They died, they collected the money and distributed it out, and now the beneficiaries are saying, hey, you could have bought $5 million more death benefit with that. You could have arbitraged that. When mom was 87 and still in good health, you could have sold that policy on the market and bought a much higher death benefit, and she wouldn't have to pay any more premiums. All of that is going on now. And that's why, and I don't think I have it in this presentation, there's something called decanning and allocation of duties. What you can set up now is you can act as the trustee solely responsible for the flow, but you can have the client appoint someone responsible for reviewing and making sure the policy and the investments are the correct investments for the trust. So you can separate out the duties of the trustee between pure administrative and the investment oversight. And you're going to see more and more of that. Yes?
How did you you make that assumption based on underwriting characteristics after the person's dead? What would have been their underwriting classifications back?
How could you have?
Yeah.
It doesn't matter. They can go back at the premium, and I'm sure if I've never met, and this is with the best intentions that I'm saying this, I've never met an insurance agent that didn't tell me they could have done better on a particular policy than the one the client has. So I don't care. I can show you an illustration, and I know that someone could do better than that. And so that's how the argument goes, and we see it all the time. There's even a case that's so disturbing, and it didn't involve insurance. Just one second. It's so disturbing. Mom and dad wrote in their trust they own X company stock, and the trustee is never to sell X company stock. The trustee wrote to the grantors every year, we want to sell the stock. The mom and dad said, no, you can't sell the stock, no, you can't sell the stock. So they didn't sell the stock went in the toilet, the beneficiary sued, and this was a bank, and won, saying, it doesn't matter that you told them, you should have just done it. And the bank was right. The bank was completely in the right in that situation, but that's what happens in litigation. Michael?
What about like the remaining?
Not you, Michael. Not Michael. Sorry.
If beneficiaries can come in the future, how do you protect yourself? You got a very conservative client. All he wants is a simple, UL survivorship policy. Doesn't want to take any market risk. Makes his intentions clear. You're happy to do the policy. How do you protect yourself 10, 15, 20 years down the road when you get some ticked off beneficiary had you sold them a variable policy?
Well, I think...
Look what this could have been. Instead, you got to show different types of policies.
The question is...
Have them rejected to protect yourself in the future?
The question is, how do you protect yourself? I think as the agent, you have an obligation to show the